Hi, this is Ann Breuer with First Choice Realty Solutions, and we're here today with Alex Crosby, and you are an estate planning attorney, and you've been practicing law since 2006. Alex, thank you for joining us today.
Thank you for having me. I'm happy to be here.
Great. Is there something you'd like to tell us about what you specialize in to maybe start off with?
Sure. I'll tell you a little bit about where I came from. I graduated from law school in 2006 and immediately started with a law firm in downtown St. Paul, doing mostly estate planning work. And that's what that law firm did. They focused very much on doing wills and trusts. And so I immediately got thrust into the middle of that. And to be honest, coming out of law school, I didn't know exactly what I wanted to do. I knew I wanted to practice law, and that was where my thought process stopped. But I ended up working at that firm for about 7 years and really started to enjoy the estate planning piece, and felt like a type of practice of law where I could be constructive and help people. And so in 2013, I started my own firm with one other lawyer that we actually worked together at the previous firm I worked at. And we've been working together for 12 years now, coming up on 12 years. And I've just found that it's been a very interesting and satisfying area of law to work in. So it's been something that's been very positive for me, and I'm happy to be where I am.
I know we personally worked with you as well as clients, and we've been very pleased. So, say a couple questions. What is the difference between a will and a trust, and what's important about that?
Sure. Yeah. So the main practical difference between a will and a trust is probate for most people. But I want to give you some context for that so I can explain a little bit about what that means. So first of all, probate. So what is probate? Probate is the court-supervised process for transferring assets at death. And probate is triggered when a deceased person owns an asset, or more than one asset, in his or her name alone at death. So for example, if I owned a house or a bank account in my name alone and I died, generally you would need a probate to transfer that. And essentially what happens is the asset gets stranded in the deceased person's name, because if it were my house or my bank account, only I could sign a check or sell the house. And if I'm gone, obviously I can't do that. So what would happen in that case is somebody, my wife or my kids, would have to go to the court and file a petition. And the petition would just basically explain the situation, that somebody has died, there are assets there that need an administrator. And the probate judge would then review that petition. If everything's in order, the judge would issue an order saying, okay, we're going to appoint somebody to be the personal representative. And personal representative is just the modern term for executor. It's the person appointed by the court to manage the assets. And that order would specifically give somebody the authority to step into my shoes and take control of the assets and do what needs to be done. And what needs to be done is typically gather up the assets, pay off the final bills, and then distribute the assets according to what the will says. What I tell people is probate is not the end of the world. It's not a catastrophe. But at the end of the probate process, all the assets are going to be distributed according to somebody's will. So they'll get where they're supposed to go. But the court process adds delay and adds cost to it. And it's usually a good idea to plan to avoid probate, to avoid those costs and delays. And one other factor is that a probate is public by default. Any court proceeding, with some exceptions, is a public proceeding, and anybody could go down to the courthouse and look up your will or the inventory of your assets. And so privacy may be a concern as well. So the will, like I said, the will is still going to control what happens to your property, but it's going to happen through this probate process. So if you're trying to avoid probate, how would you do that? One way is to use a trust. And in this context, there's many different types of trusts. But in this context, we're talking about a revocable living trust. And it's living because you set it up during your lifetime. And it's revocable because you have the power to amend or revoke it at any time. So with this type of trust, you don't give up any control over your assets during your lifetime. And essentially what that trust is, or that the trust is created by a written document that has instructions for what to do with your property. And in that sense, it's very similar to a will, because the trust will say, when I'm gone, give my property to my spouse or give it to my kids. And the big difference between a trust and a will is that if you set up a trust and transfer your assets into that trust, then all of those assets in the trust don't need to go through probate. You can appoint a successor to yourself to take control of this trust container and all the assets in it and carry out your instructions, which would be to pay the final bills and make sure the assets get to your intended beneficiaries. So the basic difference between a will and a trust is that, let me back up just a little bit. So the similarity there is they both contain instructions on what to do with your property when you're gone. But the difference is the will is going to require a court procedure to get your assets where they're supposed to go, whereas a trust does not. And so for a lot of people, that can be a big benefit, primarily in terms of making things easier for your family or for your beneficiaries. And that's really one of the main goals, I would say, of doing estate planning, is to make things easier.
Perfect. Thank you for sharing that. So what would you estimate as a typical timeline when a property goes through probate, or is there a typical timeline?
It really depends on a lot of things, and sometimes it depends on what needs to be done.
Sure.
As you know, that sometimes if you have to sell a house, that can take some time. And particularly if it's the family has to clean out the house and then put it on the market. But I would say just from the court process, you're probably adding at least 6 months to the overall administration timeline, and probably adding several $1,000s to the cost of getting from point A to point B.
Okay. Yeah, and that's pretty critical. Alex, when is it necessary to update your estate plan?
Sure, that's a good question. I think it's worthwhile to update or review your estate plan at certain critical life milestones. When there's a major change in your life, it's worthwhile thinking about whether you need to update your estate plan. So one of those would be, obviously, if you have a change of mind about who you want your beneficiaries to be. And so that'd be something that would trigger a need to take a look at your estate plan. But just in general, one major milestone would be having a child. Once with an estate plan, you can provide instructions for managing an inheritance for the benefit of a child. And you can also nominate someone to act as a guardian for your children. And when I think about this, one of the tricky things about estate planning is that we are not discussing cheerful topics. We're talking about death or incapacity. But the idea, like I said a minute ago, is to make things easier. So you can do a plan that makes the legal and financial sides of this a lot easier at a time that is going to be a difficult time. If you're putting a plan into action, anything we can do to make that a little bit easier is worthwhile. The other component there about having a child is in Minnesota, once a child reaches age 18, they're a legal adult. And if you've left an inheritance to a child directly, a court would supervise that inheritance until the child reaches age 18. But at that point, the guardrails are gone and the child would take that inheritance unless you've done some extra planning. When I think about, I should not have been in charge of any substantial amount of money at age 18. When I think about where I was at that point, and for a lot of people, that'd be something to plan for or plan around to help protect, in that case, protect the beneficiary from him or herself.
Absolutely.
And another major milestone would be retirement. And I think that kind of tends to line up with a point where if you have kids, your kids are adults and probably have been established in their career or whatever they're going to be doing. And also at that point, you've accumulated some assets, and an estate plan that you did when your kids were young might not be a good fit anymore because the kids have changed, your circumstances have changed, your assets have changed. And that'd be another good opportunity to take a look at your plan and say, is this still a good fit? A third example is moving to a different state. So each state has slightly different rules about probate and transferring property. And different states also have very different laws about marital property. So in particular, if you're married, it'd be very important if you move to a different state to have an estate plan reviewed by a local lawyer. For example, Minnesota and Wisconsin have very different laws about how property of a marriage is treated. And there are some benefits and pitfalls to that. For example, if you move from Minnesota to Wisconsin, there are some very significant income tax benefits that you could have from setting up a plan appropriately. And that would be a missed opportunity if you don't have somebody review the plan and make sure it is optimized for Wisconsin law.
That's a great point, because that's probably going to be the last thing on somebody's mind when they're making a move to another state, right? Think about the state plan.
Yep.
Well, thank you for sharing.
And the last one I'll mention is just something like buying a house. And sometimes that would coincide with moving. But a house is for a lot of people the most significant asset that they'll have. And it's one that is easy to get stranded in probate. So even if you're married, so that's something to look at as well. It's some kind of a milestone like that to say, we have this, but we should do some planning to figure out what happens to it if something happens to us.
Absolutely. How does an estate plan protect assets and make things easier for the family?
One benefit of the estate plan, or how it makes things easier for a family, is avoiding probate. We talked about that earlier.
Mm-hmm.
Another is saving on taxes. There's some significant tax savings or planning that can be had. And we'll talk about that, I think, a little bit later. But one major benefit of estate planning is the option to leave assets to a beneficiary in the form of a trust. And with a trust, you can appoint a trustee, which doesn't have to be a lawyer or a bank. Oftentimes it's a friend or a family member. But you can appoint that trustee to act as a gatekeeper to the inheritance. And that can be used to protect an inheritance from the beneficiary's creditors or from the beneficiary, him or herself. So for example, you could leave an inheritance in the form of a trust to a young beneficiary, like we said earlier, or a beneficiary who may not be young, but needs extra assistance managing the money. And I know sometimes I work with clients who have children that have substance abuse issues or creditor issues and just struggle with managing money. And the parents are afraid to hand a large chunk of money over. And one solution to that, to protect the child, would be to leave it in a trust so that the money's there for the benefit of the child, but there's a gatekeeper to make sure that the money is applied appropriately. And sometimes we'll set up a trust that will end at a certain age. We'll say, let's have it in trust until your child reaches age 30 or 35. And then the reins get handed over to the child at that point. And in some cases, it makes sense to establish a trust for the beneficiary's lifetime. And one other example I'll offer here is if one of your beneficiaries has special needs, and there's some really significant benefit to doing a plan there. Because first, the beneficiary might benefit from having a trustee just appointed to help manage the inheritance. And second, many of the government programs that support people with special needs are only available if the assets don't exceed a certain threshold. So if you receive an inheritance as somebody who's receiving some of these government programs, you can get disqualified from government benefits that you might be relying on for housing or medication or something like that. And so receiving an inheritance can be very disruptive in that kind of context. But there are some tools that you can use in terms of setting up a trust for that beneficiary that can avoid that and preserve eligibility for benefits. So those are some important things that you can look at and to help protect your beneficiaries.
Absolutely. Some great points. Thank you. What are some common misconceptions about estate planning, Alex?
Some that I've come across in my practice. One is that some people believe that having a will keeps their assets out of probate. I got a will, so I don't need to go to the court. And that's not the case. Probate is triggered by having an asset there that needs to be managed. And the will, as we said, will control what happens to that asset. But if it's a will, it's going to go through that probate court process. Another misconception I see sometimes is that you need to have significant assets before you benefit from estate planning. And the point I've been trying to make is that one of the main goals of estate planning is to have your wishes carried out and to make things easier for your family and beneficiaries. And you don't really need to have a lot of assets to benefit from that. If you've got a house and a retirement account and a bank account and a car, there's still going to be savings in terms of time and money by doing a plan in advance. Another misconception is a fairly specific case, and I think this is an interesting quirk of Minnesota law, but it's a situation where one spouse owns the homestead. And typically, spouses will own their home as joint tenants if they bought it during marriage, but not always. And certainly there's some cases where one spouse might already own a home coming into the marriage and their name is on it and the spouse's name doesn't get added. And I think a lot of people assume that if one spouse dies, the house is going to go to the surviving spouse. But if the home is only owned by that one spouse and that spouse dies and no planning has been done, the home actually goes to the surviving spouse and to any children. And that can be a real headache if those children are under 18 because they're allowed to own property as a 10-year-old. They can own a portion of that house. But if they ever want to sell it or do anything else, they're going to have a court involved to manage the minor child's interest. So that's a niche case, but it's something where if you own your house alone and you're married, you're going to want to take a look at that and probably do some planning to make sure that you've accounted for that.
Absolutely.
And I'll throw one thing else out there is the final misconception, I think, is that you can do a plan yourself. You can download something from the internet. And I acknowledge that I'm probably biased because of my profession on this, but I think a lot of do-it-yourself plans may work out in the end in the sense that the assets get to the proper people at the end. But there's a real risk that the process of getting to that point is going to be more expensive and more time consuming than if you had talked to somebody who does this for a living and have your assets structured in a way that will transfer them in the most efficient way.
Absolutely. So did it save them anything in the long run by doing it themselves?
That's exactly it.
Big question, right?
And I will say that this is the rare case. I think most of those plans do tend to work out, but the plans where the person setting up the will has made a mistake or doesn't know the full picture, those are the ones I think where lawyers make a lot of money because those are the kind of situations that generate a fight. And then you've got multiple lawyers, multiple parties fighting over what did this will actually mean. And often that means a lot of money goes to the lawyers, and that's probably not what the person wanted when they were setting up that will.
Yeah. Thank you for sharing that. So how should someone start the estate planning process?
So leading from what we were just talking about, I think the best start is to talk to a lawyer. I think if you ask friends or family for a referral, that's a great place to start. They may have done a plan and they have somebody they could recommend. You can also talk to your accountant or financial advisor or other professionals you work with, and they may have a recommendation. Many lawyers will do a free consultation to discuss your situation and then make a recommendation on a plan. So I think a lot of times that meeting is really good to call out issues and make people aware of what their estate looks like and what the benefit of doing a plan would be. But I think that's the best place to start. And then when you're thinking about your estate plan, some of the important questions are, who are your beneficiaries? Who should receive your estate? And then also in that thought is, what if your first choice dies before you? Is there an alternate? And that's important too, because with most estate plans, you can always change it, but that doesn't always get done. So in most cases, I try to push people to say, this person isn't around. Where should their share of the estate go? And make sure that they've thought about that. And then a second point is thinking about who should act as your personal representative or your trustee to manage and settle your estate. And sometimes I talk to people and they say, I want to name our eldest child because it's their turn or that's what they should be doing. I tell them it's not really an honor you're bestowing on them. It's a job you're asking them to do. So you want to think about, is this somebody who can handle the responsibility? Is this someone that lives locally? So geography can make a difference there. But to think about that, think about who you would pick to carry out your wishes. And then finally, putting together a list of your assets. So you can say there's different tools that we use for transferring a retirement account versus a house. So it's important to take stock and have a plan for each asset that you own.
Absolutely. Take some time and think through that. And just, I can see that thoroughness of thinking through who you choose being very critical. What documents are essential in an estate plan besides a will?
As we talked about earlier, one essential document is a document to provide instructions on distributing your assets after death. So that would be a will or a trust. But the other component to doing a complete estate plan is to look at lifetime planning. And I recommend that clients also sign a power of attorney for financial matters and a healthcare directive. And those are documents that name one or more people to act on your behalf if you were to become incapacitated. So the power of attorney gives somebody the authority to step into your shoes and do anything basically with your assets that you could do. And the healthcare directive appoints one or more people who would be able to talk to your doctors and make health decisions if you're not able to. And the planning point there is if you do become incapacitated and you can't make decisions for yourself or manage your assets, and you have not given somebody authority under one of these documents, then your spouse or children would probably need to go to the court again to ask that the judge appoint a guardian. And again, like probate, that's something where it's going to add time, it's going to add cost, and there's a chance that the person you prefer might not get appointed. But if you've done the power of attorney, that gives you the chance to name the people you like or entrust and also have them act without having the court as friction there to add cost and expense.
Absolutely. And it might occur during a critical phase if somebody's in the hospital or something like that. That could be pretty inconvenient.
Yep. And I'm sure you've dealt with that at times with working with your clients and trying to figure out a sale or a purchase and losing authority or not having the right papers in place.
Yeah. And it's hard to see because they're going through a loss or a very stressful time. So are there any tax implications to consider?
One major tax consideration is the estate tax.
Okay.
And the estate tax is a tax on transfers of assets at death. And there's a federal level estate tax, and then several states, including Minnesota, have a state level estate tax. And the way that tax works is the tax authority basically takes a snapshot of everything you own on date of death. And if the asset value exceeds a certain threshold, you pay tax on every dollar over that amount. And there's some exceptions and permutations to that, but that's basically the way that it works. The federal exemption is currently $13.99 million, which means you wouldn't pay a federal estate tax unless your estate exceeds that. So most people don't need to worry about the federal estate tax. But if you do have an estate over that amount, then it'd be important to do some planning. Minnesota also has an estate tax, which applies if you have more than $3 million in assets. And that's pretty high too, but it does hit more people than the federal estate tax does. And there are a number of estate planning tools that you can use to plan for this estate tax. And if your estate exceeds $3 million as a Minnesota resident, there can be some significant tax savings from doing advanced planning. So that's not a consideration for everyone, obviously, but that is something where there's some real opportunities in planning to address that tax and plan around or for it.
Thank you for sharing that. I think there's so much to consider, and I appreciate that you took the time with us today. And I just wanted to share a quick story. You had worked with a client, I don't want to give out her name, but she worked for over a year to help her friend. So they weren't even
Mhm.
family, but she helped her friend for a year to get into a living that suited her needs and to help her clear out her house. And then we ran into an issue with some documentation, and you really went to bat for her. And I just want to say she was so grateful of how kind and how generous you were with your time and helping her. I just wanted to share that story because we don't always hear good stories. And it's just nice to be able to spread that news. So thank you for joining us today, Alex.
Yeah, thank you. I appreciate hearing that. Thank you for taking the time to listen to me. Appreciate the time and good to talk with you about this.
All right. We look forward to talking with you in the future, and you have a great day.
Thanks, you too.
All right. Bye bye.